You cannot go onto the curtilage. How many times do we have to say curtilage before you actually understand curtilage? In the late 1700s, the framers of the Constitution could never have envisioned the Fourth Amendment issues that are coming before the court today. The original Fourth Amendment framework was rooted in what was called the trespass model. It involved a property right belonging to the citizen and a physical intrusion of the police onto that property, what would otherwise be described as common law trespass. The core idea behind this doctrine is that a search occurs when the government physically intrudes upon a constitutionally protected area, like your person, your house, your papers, or your effects, as specifically mentioned in the Fourth Amendment. The violation was determined by where the officer was, what physical boundary was crossed, and whether there was probable cause to do so. The rule: no intrusion, no search. What that meant was, if they didn't step onto your property, the Constitution did not step in to protect you. But all of that changed with a case called Katz. My name is Shelley Behan, and this is Fourth Amendment Friday. The Katz decision changed everything. The notable quotable from that case was that the Fourth Amendment protected people, not places. Justice Harlan's declaration came with a two-part test. Is there a subjective expectation of privacy? And if so, is that expectation one that society is prepared to recognize as reasonable? As a reminder, the government intrusion at issue in Katz was a listening device placed on the phone booth by federal agents to record Katz's side of the call. Since phone booths were all the rage back in the day, the Supremes reasoned that a person making a call in a closed phone booth had indicated an expectation of privacy, and it would be one that, as a society, Americans were prepared to say was reasonable. Otherwise, the government could listen to any phone call it wanted, provided it was placed in public. What the Katz decision did was move the doctrine from purely physical intrusions to a consideration of privacy expectations. This is a critical shift. It meant that a search could occur without any trespass at all. There didn't need to be a physical intrusion for there to be a search. Katz expanded the Fourth Amendment, but it also made it harder to enforce. This is because property rules are clear, but privacy rules are fluid. Let's look at some cases. First, U.S. versus Jones, a decision from 2012. This is a case where officers installed a GPS tracker on a vehicle. It was held to be a Fourth Amendment violation because the officers intruded upon an effect, namely the car, without a warrant. Now, the officers actually had a warrant, but it authorized installation of the tracker within the District of Columbia and within 10 days of the time the warrant was issued. The government installed the tracker in Maryland, not D.C., and they didn't install it until the 11th day. Because the agents acted outside the dictates of the warrant, they trespassed. In that case, the government was fully focused on privacy analysis, arguing no reasonable expectation of privacy in the underbody of the vehicle, nor its movements along a public roads. Really? Then why did you get a warrant to begin with, officer, if you thought there was no issue? Nevertheless, the Jones court, led by the late Justice Scalia, found fault with the notion that Katz, in its privacy test, was the only way to examine the case. Scalia noted there was no authority for the intrusion to the vehicle and found a Fourth Amendment violation. The concurrence, led by Justice Sotomayor, said long-term surveillance of any individual through the means of an electronic device is a Fourth Amendment search, and without a warrant, it is a Fourth Amendment violation, since such monitoring creates a full picture of a person's public movements, which inevitably will disclose private information about them. By reviewing the trespass model, the Jones decision said, you have privacy, that's true, but we don't need to go into it if there's a property-based violation. So while the Jones case offered the opportunity for the court to declare that such a surveillance was a Fourth Amendment intrusion, it would not be until the Carpenter decision in 2018 that the court held where historical cell site information used for the purposes of tracking a person required a search warrant. Let's consider another case, Florida versus Jardines, where the police brought a drug-sniffing dog onto the front porch of the residence. The dog alerted, because of course it did, and a search warrant was obtained for the premises. Marijuana plants were revealed. This was a 2006 case, which was heard by the Supremes in 2012 and decided in 2013, and Jardines was charged with drug trafficking. No good, said the Supremes. Justice Scalia, leading the way again, said these officers took a dog onto the curtilage. You cannot go onto the curtilage. How many times do we have to say curtilage before you actually understand curtilage? This was a deeply divided decision, 5-4. The majority obviously found a search and differentiated between officers knocking on the door and hoping to talk to an occupant from someone taking a drug-sniffing dog to the door. The only purpose of the drug-sniffing dog is to search for the odor of drugs. The dissent, authored by Justice Alito, found no issue with the presence of the dog on the porch and no reasonable expectation of privacy in odors which would be expected to escape from the home. Now you might be thinking, if there's a reasonable expectation of privacy and odors escaping from an otherwise protected place, how can the police run a drug dog around my car at a checkpoint or during a traffic stop? Because you gave them consent to do it by operating the car in public. In 2005, the court heard a case called Illinois versus Caballes, which held that there was no violation of the Fourth Amendment in running a dog around the car if there was no unreasonable extension of the length of the stop. So if one officer is writing you a speeding ticket and the other officer is running a dog around the car while that is happening, there is no Fourth Amendment violation. Now I could go on and on about the cases that these decisions touch, but look at the overlap between privacy and property in both Jones and Jardines. Both effects and curtilage remain deeply protected property interests. While they overlap with the privacy concerns, there is not a need to prove a property interest when a defendant can prove trespass. It is often an easier route to take, frankly, since trespass asks what the government did, not what society thinks about what the government did. So while Katz was framed as a Fourth Amendment revolution, and to be sure it didn't disband the property protections from the trespass doctrine. As Jones and Jardines reveal, property is still the baseline protection. This is important because as society changes, privacy interests can shrink. Property, being more fixed and historically grounded, then becomes the stronger argument. But the court isn't asking citizens to choose between privacy and property. It is using both doctrines without fully reconciling them. Maybe such reconciliation is impossible, despite the doctrines being so intertwined. If privacy depends on a societal sanctioned expectation, that can change. If it depends on property, it holds. The court is using both, and ultimately, the Fourth Amendment is stronger for it. And that does it for this week's episode of Fourth Amendment Friday. Tune in next week when we go deeper into privacy and technology. Until then, stay free, stay fabulous, and remember your fundamentals. My name is Shelley Behan. I'm the host of Beyond the Breathalyzer, and your rights are my priority.